Hello, greetings everybody, and welcome to PPMT IMT 2025 February. Out of almost 50 teams, we are now at the elimination rounds, where I believe it's the third seed facing off the fifth seed. Now, we're going to begin in just a moment. My name is Max Wong. I'm one of the co-founders of, well, both PPMT and IMT, and I'll also be one of the scoring judges today. Very, very excited to be here. I just hope that all the competitors here can have fun. And what I look for in the round is to see whether or not that the students are reacting to what's going on in the round. And that's pretty much it. I hope you guys have fun. Having said that, Judge Jordan, if you could introduce yourself.
Hi, everyone. I'm really glad to be able to judge this semifinal round. I am currently an undergraduate student at Vanderbilt University on their mock trial team. So I know a little bit about what you're going through. I love to see a strong command of the facts and of the rules of evidence, and I'm sure we're going to get that today.
All right. Judge Noodleman, if you could introduce yourself as well. And when you're done, just take it away.
Sure. Good day, everyone. Stephen Noodleman. I'm an attorney in New York, New Jersey area for the past 30 years. I've judged mock trial at all levels, college, high school, as well as this tournament in the past. Very happy to be here. Good luck to everybody. And I agree with Max. Everybody should have a good time. And with that, let's call a case of State of Tilly versus Jimmie Tanks. Can counsel make their appearances, please?
Yes, Your Honor. Before you make appearances, may I ask for your time zone, whether it's morning, afternoon, or evening?
Yes, I am in the lovely Garden State of New Jersey. It is the Eastern time zone, and it is 8:15 a.m. Eastern time.
Yes, Your Honor. In that case, good morning. My name is Sydney Liu, and together with my co-counsel, Miss Alana Sun.
Good morning, Your Honor.
Morning.
In this case, we will represent the prosecution in the state of Tilly versus Jimmie Tanks.
Okay, and the defense?
Yes, Your Honor. Good morning, Your Honor, opposing counsel, and members of the jury. My name is Mariska Campbell, spelled Campvell, counsel for the defendant, Jimmie Tanks.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Angelina Chatori, and spelled Chatoori, counsel for the defendant, Jimmie Tanks.
All right,
Your Honor,
terrific.
may our witnesses make...
Hello, hang on. I only asked you to introduce yourselves. Just take
Your
it easy.
Honor,
It's
I
your...
was going to ask if our witnesses can introduce themselves.
Oh, sure. By all means, let's hear witnesses too while we're at it. Go ahead, please.
Thank you, Your Honor.
Good morning, Your Honor. My name is Danziah Curry, and today I will be Inspector M. Reynolds.
Okay.
Good morning, Your Honor. My name is Brennan Blenar, and today I am Jimmie Tanks.
All right, Mr. Tanks, you want to make sure you speak up so we can hear you, okay?
Yes, sir.
Terrific. Okay, with that, now can we see, does the prosecution have any preliminary matters they wish to raise to the court?
Yes, Your Honor, just a couple. First, we'd like to invoke Rules 615 and 603, the constructive sequestration and swearing in of all witnesses.
Okay.
Next, we'd also like to ask Your Honor's preferences on screen sharing, whether we should state for the record or ask for your permission.
I kind of like it if you do it as you do, say it as you do it, kind of like, Your Honor, we are now sharing such and such, and that's fine.
Yes, Your Honor. Lastly, we just like to note that in the captain's meeting before this trial, which Your Honor likely witnessed, we exchanged character evidence forms, and prosecution is intending to offer some 404B2 evidence, and defense currently has no offer of character evidence.
Okay. Anything else?
No, Your Honor. With that, the prosecution is ready to proceed.
All right, well, let's check with Ms. Campbell first and see if she has any preliminary matters she wishes to bring to us.
Yes, Your Honor. Prosecution invoked Rule 615, but we would like to designate our party as a defendant, Jimmie Tanks, and they will not be sequestered in today's trial.
Okay.
And when making arguments to objections, can we assume that is outside the presence of the jury?
As they say in the great state of New Jersey, we never assume. That
Yes,
means
Your
that if you
Honor.
want something stricken, please say so, okay?
Yes, Your Honor. And with that, we are ready to proceed to opening statements.
Terrific. All right, let's hear from the prosecution. We are listening.
Yes, Your Honor. May I proceed?
Please proceed.
May it please the court, opposing counsel, and members of the jury. Caught on camera, caught on paper, caught for revenge. It was midnight of July 1st. Jimmie Tanks, the defendant, stands in front of Bertie Darrow's house, holding a red plastic container. And as he walks on the perimeter of the house, slowly, step by step, and then takes the gasoline, pours it out, and sets it on fire. His revenge almost achieved. Almost, because he was caught by the security camera that was across the street. But why did Mr. Tanks want revenge? Because 3 years ago, Mr. Darrow caught Mr. Tanks stealing from a pawn shop, and Mr. Darrow reported him to the police. And because of that, Mr. Tanks had to go to jail for 3 years, losing his education, losing his scholarship, losing everything he owned. And he hated Mr. Darrow for that. And that hate was why he needed the revenge. Caught on camera, caught on paper, caught for revenge. Members of the jury, today, we, the prosecution, are charging Mr. Tanks for first-degree arson and attempted first-degree murder. For the counts of arson, we must show that Jimmie Tanks intentionally burnt down Mr. Darrow's house with Mr. Darrow in it, which needs substantial step towards the counts of attempted murder. And we need to prove beyond a reasonable doubt. That means that all the evidence to prove beyond the reasonable doubt, the camera, the paper, and the revenge. That's why we're putting Mr. Tanks on trial today. As a prosecution, we are going to provide you with facts of this case. And the evidence will convince you and prove to you beyond a reasonable doubt that Mr. Tanks is guilty of these 2 charges. Members of the jury, in today's case, you will hear 3 facts from the prosecution. First, the camera. Second, the paper. And third, the revenge. First, the camera. We would provide evidence that shows how the defendant was caught on the security camera. When an expert in forensic video analysis, he'll tell you all about how the man who appeared on the security camera is in fact the defendant, Mr. Jimmie Tanks. Second, the paper. We will prove with evidence, the receipts, that the defendant has bought gasoline. And through this, members of the jury, we will prove that these paper proves that the defendant's intention to the trial. Third, the revenge. You will also hear from our witness, the enemy of the defendant in high school. He'll tell you why the defendant wants to put revenge on him. Old day high school memories that is kept to now. Caught on camera, caught on paper, caught for revenge. He was caught multiple times on the camera, the paper, and the revenge. That is not a coincidence. And that is why, at the end of this trial, my co-counsel, Ms. Sydney Liu, will come up to you and ask you for a verdict of guilty.
I thank you, Ms. Sun. All right, can we hear now, please, from the defense?
Yes, Your Honor. $1 million. When prosecution came up here today, that's something they didn't mention. $1 million. Now, that's a whole lot of money that can solve a whole lot of problems. In today's case, you will see that the motive for the burning of Bertie Darrow's house was not from a forgotten rivalry, and the culprit was not Jimmie Tanks. In fact, it was Bertie himself. And that's why the motive lies in the $1 million payout. Now, prosecution did not want to tell you about Bertie Darrow's real life. So allow me. Darrow was desperate. He was in serious debt. He owed $10,000 for personal loans, $15,000 for credit card debt, $200,000 for his mortgage payments, and on top of this, a new gambling addiction. Then, two things happened. He recently inherited a house from his great aunt with a $1 million insurance policy, and his old rival, Jimmie Tanks, shows up to town. So Darrow saw his way out of these two problems, and he took advantage of this disliking and his insurance policy, then set his new home on fire to get to his $1 million payout, pointing the finger at innocent Jimmie Tanks as the culprit. This isn't a case about revenge. This is a case about $1 million payout. As the defense say, we do not have a burden. It is the prosecution who is held to a burden, and it is on them and solely on them to prove to you beyond a reasonable doubt that my client is guilty of first-degree arson and attempted first-degree murder. Beyond a reasonable doubt is the highest and heaviest burden in our justice system, and it means it is the prosecution who must get you to an abiding conviction of guilt. As the defense, we can sit at our desk and do absolutely nothing, but we won't do that because we want you to know the truth. One, that Jimmie Tanks is not guilty, and two, that the motive lies in the $1 million payout. To prove this to you today, we will call up two witnesses. First, Inspector Reynolds, who's an insurance investigator with over 25 years of experience in the arson investigation field. Inspector Reynolds will signify the immense debt Bertie Darrow was under, and the same immense debt that he lied about. And she'll tell you that the fuel that fed this fire was the same paint thinner that Bertie Darrow painted his house with. Now, members of the jury, our legal system takes on the concept that everyone is presumed innocent till proven guilty. So that's why, two, we were calling up Jimmie Tanks himself, who waived his Fifth Amendment rights just to tell you the truth today, that he did not set that fire. Tanks will tell you that he was just trying to build a cool project for his son, who he's been desperately trying to bond with just to be a better dad. And that's the only reason he had gasoline that day. Now, members of the jury, it's that same presumption. That means if you have any reasonable hypothesis of innocence, you have to find the verdict in favor of Mr. Tanks. And that's why we ask you to look closely at all evidence today. Because if you do, you will see that the motive lies in the $1 million payout. And that's why we ask that you find Mr. Tanks not guilty. Thank you.
Okay, thank you, Ms. Chittori. All right, let's now turn to the prosecution. Please call your first witness.
Yes, Your Honor, prosecution would like to start off by calling Mr. Darrow to the stand.
Okay, please proceed.
Yes, Your Honor. Good morning. Could you please introduce yourself to the court?
My name's Bertie Darrow, as in Darrow.
What do you do for a living, sir?
Well, I coached the varsity basketball team at Aberdeen High. It was a school I used to go to before now, and I used to play basketball there. I moved from London to Tilly in freshman year, and yeah, been here ever since.
You said you played basketball in Aberdeen High. Did you live nearby?
I did. I lived around, I'd say 5 minutes away by foot. It was at my Aunt Lucia's house. It was just down the street.
Does that mean that you live with your aunt, sir?
Well, no, I don't. She actually passed away, I'd say January of last year, 2024. I inherited the house, though.
I'm sorry for your loss, Mr. Darrow. Do you have a good relationship with your aunt by chance?
I'd say I do have a very good relationship with her, and don't be sorry, my dear. It's not your
Objection, Your Honor, relevance.
Lou, what do you have to say about that?
Your Honor, this is incredibly relevant to the case. It is important to know that Mr. Darrow's house, the house that burned down, isn't just his house. It was also his aunt's house. And this goes towards challenging the defense's alleged motivation for Mr. Darrow to burn down his house, because if it was his aunt's house and it was valuable to him, he wouldn't do it.
Your Honor, may I be heard?
Sure.
Your Honor, while prosecution can say how valuable this house was to Darrow, what's not relevant is his relationship with his aunt, and therefore this does not go towards a fact of consequence in today's case, and is not relevant.
Your Honor, if I may.
No, the objection's overruled. The relevance is a fairly low bar, and I believe that counsel has met that standard on the first argument. So let us proceed.
Yes, Your Honor. Mr. Darrow, back to my question. Do you still live in your aunt's house today?
No, I don't. Someone, I believe, or something had burnt it down in a fire last summer.
So why are you here in court today?
Because I'm here, because I lost my house, and most importantly, it was my aunt's house first, and every single thing inside. I'm here to tell you about who did it. Jimmie Tanks.
Mr. Darrow, I want to start from the beginning. Do you recognize the defendant in this courtroom?
Yeah, I do. Said so. It's Jimmie Tanks.
How do you know Mr. Tanks?
From high school. He was in most of my classes throughout the 4 years.
Could you tell us a little bit more about your relationship with him in those 4 years?
Well, I can tell you something. We definitely weren't best mates. Never really liked him, to be honest. But in our senior year, an incident, changed whatever relationship we did have permanently.
Could you tell us a little bit more about that one incident?
Of course, we had a bit of a run-in around February of 2021. It was after school. I was walking to the local pawn shop, and as soon as I walked in, I saw Jimmie Tanks. He was shoving what looked like an object almost, with a diamond center into his backpack.
Well, do you know what he was doing that for?
Well, it certainly looked like he was stealing, so I just pulled out my phone out of my pocket and took a photo as soon as I could.
What were you going to do with that photo you took?
Being completely honest, I was going to use it as evidence to turn it in to the police. My Aunt Lucia, actually, she used to run a small bakery back in London. It was in Brixton, I believe, and she always showed me how devastating theft was for small businesses. I just could not let him get away with that.
So, after you took that picture, did Mr. Tanks see you?
He did. As soon as we glanced at each other, he started chasing me and started screaming, "Don't tell the cops! I'll lose everything! My scholarship, my college!" But I just ignored him and just ran away.
So, did you ever see Mr. Tanks again after that incident?
Once, I believe, it was 3 days after I reported him to the police. It was after school, just got out of the school gate, and all of a sudden I saw Jimmie just storming up to me outside of my school. His face was clenched like this, and he looked so furious almost.
Did he say anything to you?
He did. He threatened me. He said, "I know what you did. I'm going to jail for 3 years because of you, and you're gonna pay big time when I get out. I'm gonna kill you." In those exact words, I swear to God.
Sir, did you respond to those threats?
No, I didn't. I just backed away. I mean, I was so afraid that he was just gonna explode on me at that instant. And after that, I never saw him again until today's trial.
Mr. Darrow, I want to move now to talk about the night that your aunt's house burned down, if that's okay. When was that?
It was evening of July 1st, 2024.
July 1st. And did you notice anything suspicious around your house on July 1st?
Anything suspicious? You could say so, I did. Around 2 p.m. I had just gotten home from grocery store, went to pick up a few groceries for dinner, and as soon as I got out of the car, this smell of gasoline, it hit me. And a few seconds later, I heard this shuffling noise. It sounded like almost the sound of sneakers shuffling against the pavement. It sounded like a human being.
Did you ever go to investigate this noise you heard?
I did. I thought it was suspicious, so walked around the house, like, took a quick circle, got to the garage, and that's where I saw this figure in my neighbor's trees. It was dark, but I could tell that figure looked eerily similar to Jimmie Tanks.
So why do you think that Jimmie Tanks would be in your yard?
Well, I just said so. He literally threatened to take revenge on me 3 years ago. He threatened to kill me, to take everything that I loved from me. I mean, who else could it have been?
So, sir, after you saw those noises, heard that figure walk by, what else happened that evening?
Well, I went home. It was just like any other ordinary evening, to be honest. Went home, took a shower. As soon as I got on my bed, I fell asleep because I was dead tired, and the next thing I knew, I woke up to this smell of gasoline, the same smell I had smelt earlier. And then there was smoke, and then it hit me. For heaven's sake, my entire house is on fire.
Mr. Darrow, did you manage to escape the fire safely?
Well, I'm sitting here today, am I not? So I did manage to escape, but came out just a little burnt arm here. Nothing else in that house managed to escape with me, though. Nothing else.
Well, did you leave anything else behind in that house?
You're asking me if I left anything else behind?
Yes, sir. Was there anything else left that you didn't take in your house?
There was so much in that house. I mean, it was my aunt's house first before it was mine. There was furniture. There was photos, lots of photos from the family vacations she used to take me on in summer. There was that pair of Nike Air Jordans that she bought for me on my 13th birthday. There was that pair that I didn't throw away even after she died because I knew it meant so much to her and so much to me. I mean, there was so much in that house. It was so full of life.
Objection, Your Honor. As to 403, may I be heard?
Sure. Go ahead, Miss Campbell. We're listening.
Your Honor, the witness is going very in depth and has said numerous times how they had so much in this house. This is needlessly cumulative due to the fact they have already established this numerous times, and this can go towards inflaming the jury. While we understand that the bar for 403 has to be substantially more prejudicial, this is because since this witness is only saying it's Jimmie Tanks and how the emotional value of this house, it's already been established. Therefore, it's needlessly cumulative, and the passions of the jury can get inflamed from this.
Okay, Ms. Liu, what do you have to say about this?
Your Honor, as opposing counsel mentioned, the bar for 403 is very high. Something needs to be substantially more prejudicial than probative in order to meet that bar. And here the probative value is exactly as opposing counsel said. The witness is laying foundation for why this house was so important to him, not only because it was an old family member's house, his aunt's house, but also because of the various possessions inside. The fact that he's expressing his grief and loss at having lost all those possessions makes it even less likely that he caused all those possessions to be thrown into flames, to be burned down. That again challenges the defense's motive for Mr. Darrow to burn down his house because he simply wouldn't want to lose all those items he's talking about.
Your Honor, may I be heard?
No, Ms. Campbell, I have a question for you, though. My question for you is your objection to the fact that he is repeating stuff and being cumulative, or is your objection to the testimony, the nature of the testimony that's being given, with the grief and other emotion that Mr. Darrow is demonstrating?
Your Honor, it is to us both, because the cumulativeness of him saying that he lost so much, the number of times he said it is extremely prejudicial, and also the nature can inflame the jury passions.
Okay, the objection is overruled. I just, this is one of the things that, in some sense, the ship has sailed. If you had this objection, it seemed that, that this could have been raised a whole lot sooner. As it relates to the cumulative nature, I don't think that there's anything in the witness, by way of the testimony, that would clear that high bar of Rule 403. And I think that the witness has emotion given this factual circumstances. I don't think that the evidentiary rule would go to change that. So the objection is overruled. Continue.
Yes, Your Honor. So, Mr. Darrow, all those items that you said you lost in the fire, do you know who did this to your house?
Jimmie Tanks. I've said it before, and I said it. I'll say it again. He wanted revenge, and he threatened me, and he got
Objection,
revenge.
Your
I hope
Honor.
you be.
What is the basis for the objection, Ms. Campbell?
Improper opinion. May I be heard?
Okay, go ahead.
Your Honor, this witness has testified that Jimmie Tanks wanted revenge and that he set the fire, and he is saying this definitively. Your Honor, this is an improper opinion because he is testifying as to the ultimate issue of today's case, whether or not Jimmie Tanks set the fire intentionally. While defense does not have an issue whether or not Mr. Darrow says Jimmie Tanks set the fire due to the fact that they are the victim, we have an issue with the fact that Mr. Darrow is saying he did it intentionally because he wanted revenge.
I understand you hang on, Ms. Liu. I understand you completely, Ms. Campbell. What is the legal authority for your position that this witness cannot testify as to his opinion as a fact witness about what went on here?
Your Honor, pursuant to 701, this is improper opinion, and pursuant to 704, this is ultimate issue.
Okay, so let's take a look at the rules that you're referring to. 701. Okay, so what is the problem under Rule 701? I'm reading Rule 701 now. What is the problem under Rule 701, Ms. Campbell?
Your Honor, the issue is that this is not based off the rational basis of this witness. He cannot tell whether or not Jimmie Tanks had the intention to set the fire purposefully due to the fact that he was not with Jimmie Tanks that night and does not know the mindset of the witness.
Okay, and
Your Honor, may I be heard about 704?
yes, I'm now looking at 704. Go ahead.
Well, Your Honor, the elements of first-degree arson and attempted first-degree murder is that Mr. Tanks intentionally set the fire and that he intentionally wanted to cause harm to Mr. Darrow. This is not met.
Are you reading, Ms. Campbell, are you reading Rule 704? Ms. Campbell? Are you reading Rule 704?
Your Honor, I'm stating the elements of today's case.
You have to follow the judge's question. All I asked is if you are reading Rule 704.
Yes,
Do you
Your
have it in
Honor.
front? Do you have it in front of you?
No, Your Honor.
Okay, well, I'm not sure how you can object on a rule that you don't have in front of you. So I'm going to put that
Yes.
aside for a moment and go to hear what Ms. Lewis has to say about any of this. Go ahead.
Yes, Your Honor. Under Rule 701, the prong, specifically prong A, clearly states that something only needs to be rationally based on the witness's perception in order for them to comment about it. It doesn't have to be mind reading. So Mr. Darrow doesn't have to know exactly what Mr. Tanks was thinking on the night of the fire. All Mr. Darrow knows was that right before Mr. Tanks went to jail because of Mr. Darrow, he said, "I'm going to kill you. I'm going to make you miserable." That is rationally informing his perception that Mr. Tanks wants to hurt him, possibly by setting his house on fire. And with regards to Rule 704, an opinion on the ultimate issue is not automatically objectionable as per prong A. And prong B only applies to the testimony of expert witnesses, not lay
Say no more,
witnesses.
Miss Lou. I caught that right up front, so I wasn't sure what we would talk about on Rule 704. So your point, I agree with
Your
you
Honor.
100%, and I usually don't agree with anybody 100%, Miss Lou. The objection is overruled. So please continue.
Yes, Your Honor. Mr. Darrow, I'm going to ask my question one more time. Do you know who set your house on fire?
Well, I suspected it was Jimmie Tanks. Do you hear what he said to me 3 years ago? He threatened to kill me. He threatened to take revenge on me. It was definitely him.
Thank you, Mr. Darrow. I have no further questions, Your Honor.
Okay, very good. Ms. Campbell, cross-examination.
Yes, Your Honor. Good morning, Mr. Darrow.
Morning.
Now, I want to address something you said on direct examination. You said that you saw a shadowy figure outside your house, correct?
That's correct.
Now, you claimed that this looked like Jimmie Tanks, didn't you?
Eerily similar. That's correct.
Well, Mr. Darrow, I want to talk about how accurate you are on that. This figure was far away, correct?
Wasn't. It was relatively close. Could see it around less than 100 meters.
Well, Mr. Darrow, that's pretty far away. That's not right up in your face, correct?
Yeah, but I have perfect vision, so it wasn't a big a deal for me.
Well, Mr. Darrow, your perfect vision, as you said, was not perfect vision. In fact, you had a fence obstructing your line of vision.
Yeah, it obstructed my line of vision, but I'd still say my vision's pretty clear. Didn't really obstruct it that much.
But it did still obstruct it, yes?
That's correct.
Now, Mr. Darrow, you also hadn't seen Jimmie Tanks in a while, correct?
Not for 3 years, that's correct.
Exactly. So you don't know what he looked like then, correct?
Well, I didn't know what he looked like over 3 years, but in high school, I can tell you, over those 4 years, Jimmy did not change one bit, so I doubt he changed in 3 years after high school.
Well, Mr. Darrow, you can't tell us with 100% certainty today that that was the Jimmie Tanks you saw.
Not with 100% certainty, that's correct, but I can say very, very likely for certain.
Well, Mr. Darrow, I want to talk about why you immediately assumed Jimmy was the culprit of this crime. You went to high school with him, correct?
I did.
And at this time, Jimmy used to make fun of your grades.
Yeah, he always did. I mean, never was a really bright student, but don't understand why he hated me so much for my grades.
Well, Mr. Darrow, I'm not asking you if Jimmie Tanks hated you. I'm just asking you if he made fun of your grades.
Well, that's a
Now,
yes.
now you didn't like that you couldn't be better than Jimmy, right?
I did. I admit I was a teenager back then. Every teenager has insecurity issues, and I mean, his grades were perfect. I want to have his grades.
And you didn't like that Jimmie Tanks was bruising your ego in any way?
Well, I don't know what you mean by bruising my ego, but we never really liked each other, as I stated.
Exactly. You never liked Jimmie Tanks.
I never did, but he never liked me too.
And that's why you immediately pinned the fire on Tanks?
Well, I I guess so, but I still remember there was evidence of what he said against me about how he wanted to kill me. That was definitely more swaying for that immediate perception of him being with the person who committed the crime.
Well, Mr. Darrell, you'll have a chance to address that on redirect. But now I want to address another suspect that was not looked at. You were having some financial issues, correct?
That's correct.
You were $200,000 in debt for your mortgage,
I was.
$15,000 of credit card debt,
Objection, Your Honor, best evidence.
What do you mean by that, Miss Lou?
Your Honor, they're talking about Mr. Darrow's debt currently, his financial status. There's an exhibit for that, and as such, it should be entered.
Your Honor, may I be heard?
Yes, I'm always going to let you be heard, Miss Campbell. I'm pretty big on that, but go ahead.
Yes, Your Honor. The witness knows what their finances were, so it is not necessary for this exhibit to be administered. And just because there is a document doesn't mean that this is the best evidence, and the witness can testify as to their finances.
Your Honor, if I may.
I tend to agree with Miss Campbell on this one, Miss Lou. Okay, the objection is overruled. Continue.
Your Honor.
Now, Mr. Darrow, you were $200,000 in debt for your mortgage,
That's correct.
$15,000 of credit card debt,
That's also correct.
and $10,000 of personal loan debt.
Yeah, that's correct.
This was hundreds of thousands of dollars, Mr. Darrow, right?
That's right. It was definitely not my proudest part of life.
And on top of all of this, you had a gambling addiction.
I did, but to be honest, it was just a way for me to cope with the grief after my aunt died. You know, grief makes you do crazy things sometimes, and it's not my proudest moment, but
Yes, Mr. Darrow, but this grief made you lose $2,000 just 3 days prior to the fire being set.
That's correct, but it was just, I just needed a way to cope, you know?
Well, Mr. Darrow, let's talk about your way out of debt. The $1 million insurance payout. You had an insurance policy on your house, correct?
That's correct.
And if I showed it to you, you'd be able to recognize it.
Yes, I would.
Your Honor, let the record reflect I'm screen sharing with the witness as well as opposing counsel only was pre-marked for identification purposes as proposed defense exhibit 1. Mr. Darrow, this is your insurance policy, correct?
That's correct.
It's a fair and accurate depiction.
I believe so.
It hasn't been altered in any way.
Hasn't, yeah.
Your Honor, defense offers exhibit 1.
Ms. Liu, any objection?
Yes, Your Honor, that's hearsay.
Your
Okay.
Honor.
Campbell, what do you have to say about that?
Yes, Your Honor. This is a contract and is therefore a verbal act of significance which does not constitute hearsay.
And what is the authority for that statement, Ms. Campbell?
Your Honor, this is an exception to hearsay.
Okay. And
Additionally,
what, Ms. Campbell, you got to follow my response. I asked you, what is the legal authority for the basis for your arguments? So that would mean that you could point to a rule number in the rules of evidence, or you could point to a case in the case materials. You
Your
said
Honor.
something to the effect of, this is a contract, therefore it is not hearsay. And I am saying, okay, I'm trying to follow that line of argument. What is your legal authority for coming up with that assertion?
Your Honor, pursuant to 801C, hearsay is an out-of-court statement coming in to prove the truth of the matter asserted.
Okay.
And instead, this is not an out-of-court statement, it is a verbal act.
Okay, I'll listen to Ms. Liu in response.
Your Honor, in contrary to what Ms. Campbell is saying, this is an out-of-court statement. The fact that they are showing this document written and printed shows that it is not verbal. And in fact, if they only wanted the verbal confirmation of Mr. Darrow, they could have just asked about his insurance instead of choosing to show this document, which is hearsay.
Well, and also, Ms. Campbell, Rule 801A says a statement could be a oral assertion, written assertion, or nonverbal conduct. So I agree with Ms. Liu's comment, but also the rule doesn't support your position. So the objection is overruled.
Yes, Your Honor.
Oh, wait, excuse me. Let's back up a step. I don't want to make sure I'm following this. Who offered this document in? It's early in the morning here. This is hearsay, okay? And on that grounds, this exhibit is excluded on the grounds that it is hearsay. So the objection is sustained. I want to make sure I'm getting this accurate, especially given that this is being recorded. I don't want to blow it too much. All right, continue, please.
Yes, Your Honor. Now, Mr. Darrow, you had an insurance policy, correct?
That's correct.
There were some special conditions on this insurance policy, weren't there?
There were.
One specifically related to fire damage.
I believe so.
This meant that you had full coverage on your house if there was any fire-related damage.
Of course, but I did it just to protect my aunt's house. It's so sacred to me. The thought that any fire could just devalue it like that, it scared me, so that's why I insured my house.
Well, Mr. Darrow, and that's why you set your firearm house for this full coverage insurance payout?
I'm sorry, could you repeat yourself?
So that's why you set your own house on fire for the full coverage insurance payout.
First of all, I did not set my own house on fire. I don't know where you're getting that from. I love that house more than I love myself. I will never do anything to it. But even then, if I really wanted the money, I would have just sold it for God's sake.
So it's just a coincidence that your house being set on fire has helped you pay off your immense debt.
Objection, Your Honor, that's argumentative.
All right, what do you mean by that, Ms. Liu?
Your Honor, they're not revealing any new facts with this question. They're simply saying, Mr. Darrow, do you believe this is a coincidence? They are, again, pointing out to two facts that have already been revealed by my witness. They're trying to tie them together in this question. They're not revealing any new facts. They're arguing their own position that Mr. Darrow set his house on fire.
Ms. Campbell, what's your response to that?
Yes, Your Honor. Mr. Darrow is able to answer this question freely however he wants, and I am just asking whether or not he believes this is a coincidence. And
Yeah,
argumentative.
I'm okay with you, Ms. Campbell. I agree with that. The objection is overruled. Continue.
Yes, Your
So,
Honor.
Mr. Darrow, it's just a coincidence that your house being set on fire has helped you pay off your immense debt?
Hasn't been paid off yet. The insurance company's still working on it.
But that's a yes to my question. It will help you pay off your immense debt.
Assuming that I win this trial, that's a yes to your question.
No further questions, Your Honor.
Miscellany redirect examination.
Yes, Your Honor, very briefly.
Go ahead.
Mr. Darrow, understanding your financial situation, which Ms. Campbell talked about in her cross-examination just now, did you ever want to set your house on fire?
You said that already. I would never set that house on fire. It was my aunt's house before it was mine. I would never even touch any inch of that house, let alone set it on fire. And if it was really about for money, which it wasn't, I would have just sold it instead of having to attend this entire trial. Why would I set it on fire? I would have just sold it.
Thank you, Mr. Darrow. I have nothing further, Your Honor.
Ms. Campbell, any cross-examination?
No, Your Honor.
All right, with that, the witness is excused. Thank you, Mr. Darrow. Does the prosecution have any other witnesses?
Yes, Your Honor, we would likely to call Mr. Licard to the stand.
Okay, very good. Please proceed.
Good morning, Mr. Licard. Could you please state your full name and spell out your last name for the record?
Of course. My name is Jean Lucard, spelled Locard.
Mr. Licard, what do you do for a living?
I'm a forensic video analyst at Elsa Law Firm. My interest for video analysis came from being an exotic animal photographer and analyzing if certain photos of animals are real or photoshopped.
Well, do you have any qualifications in your field?
Yes, I earned my master's in forensic science from Boston University and hold a forensic video analyst certification from the Law Enforcement Video Association.
So, Mr. Licard, how did you get involved in this case?
Well, my late mother's house burnt down on July 2nd, and my cousin Bertie Darrow gave me a call about it. He asked me to analyze some security camera footage with an unidentified figure.
I'm sorry, Ms. Chituri, were you raising an objection?
Yes, Your Honor, I was objecting as to hearsay.
What specifically is the hearsay, Ms. Chituri, so I understand?
The witness just testified that he got a call from Bertie Darrow, and Bertie Darrow asked him to come analyze the video footage. This is an
Okay.
adequate statement.
Got it. All I want to know is what the statement was. Not a problem, Ms. Chituri. Ms. Sun, what do you have to say about that?
Your Honor, hearsay is out-of-court statement made for the truth of the matter, and I believe that commands and questions don't have truth value. And in this case, Mr. Darrow requested Mr. Licard to analyze the security footage. Therefore, it doesn't have any truth value because it's requested, and it's not a statement made for the truth of the matter. Therefore,
Let's hear what Ms. Chituri has to respond to on that. Go ahead.
Your Honor, this is going towards the truth of the matter. By requesting that this video is analyzed, he's trying to prove there's Jimmie Tanks in that video, and that is why he wants it analyzed.
I do agree with you, Ms. Chituri. The objection is overruled. Well, just a moment. The objection sustained. This is hearsay. Go ahead.
Yes, Your Honor. May I move to strike?
Yes, this testimony is stricken.
Yes, Your Honor.
Yes, Your Honor, may I proceed?
Yes, Ms. Sun, please proceed.
So, Mr. Licard, if I showed you a summary of this security camera footage here today, would you recognize it?
Yes, I would.
Your Honor, let the record reflect that now we're screen sharing what has been pre-marked as Exhibit 2.
Okay.
Sir, what is this document?
It's a summary of the security camera footage at Bertie's home the night his house burned down. Security footage companies make these pretty regularly, whenever they're requested.
Mr. Lockhart, is this a fair and accurate copy?
Of course.
Your Honor, permission to enter Exhibit 2 into evidence.
Any objection, Mr. Tory?
No, Your Honor.
Okay, very well. And Exhibit 2 is moved into evidence. Please proceed, Ms. Sun.
Yes, Your Honor. Mr. Lockhart, could you point to us the timestamp when this unidentified figure appears?
That would be at 11:39 and 1 second p.m. An unknown figure walks past with a red plastic container, and from the footage, that looked a lot like they were holding a gasoline tank.
So, when did the fire start?
It starts just 78 seconds after the figure walks by at 11:40 19 seconds p.m., where an orange-red fire glow appears. That's a very short lapse of time.
What materials and information were provided to you to help you identify this figure in the footage?
I was provided with a recording and summary of Bertie's front driveway cam, as well as a photo of Jimmie Tanks.
Well, Mr. Lockhart, did you use any sort of method to validate this evidence and analysis?
Yes, and I brought a demonstrative with me today to explain it.
Your Honor, let the record reflect that now we're screen sharing a demonstrative of the expert's method.
Okay.
Mr. Lockhart, let's talk about your method. Could you please give us an overview of what these letters stands for?
Yeah, my method is the word exotic, which is an acronym for examination of the footage, analyzing the originality of facial features and bodily traits, and then forming an integrated conclusion.
Is this a reliable method?
Of course, it's a variation on a very standard forensic analysis method.
And did you reliably apply it in this case?
I did.
Then let's start from the beginning. What was the first part of your investigation?
The first part of my investigation was examination of the footage, just like how I would have to examine the natural habitat of an exotic creature, like the capybara, for example, in order to get a good photo in nature.
Oh, do you have any sort of criteria for your examinations?
Yes, for a successful examination, I'm evaluating both the quality and authenticity of the footage, and both criteria were met, as the footage was sufficiently detailed and had no traces of tampering.
So, Mr. Lockhart, what was the next step of your method?
Objection, Your Honor, as to lack of foundation may be heard.
Yes, Mr. Tory, please explain.
The witness has just testified that the video was properly analyzed and that it was reliably analyzed, yet they have not explained exactly how it was analyzed. They're simply moving on to the next step without verifying how this is reliable. Pursuant to 702C and pursuant to case law Smith v. Gupta, they must explain how this method is reliable, not just that it is reliable when applied, before reaching their conclusion.
Hey, let's hear what Ms. Sun has to say.
Your Honor, I believe that we are going to move to the next step of explaining how we use this method to reliably test the quality and the authenticity of this footage.
Yeah, Ms. Chittori, this stated slightly differently from what Ms. Sun said, but the same gist of it is, I think your objection is premature. Nothing has happened yet other than he's explaining the methodology. And I don't see anything objectionable in just explaining the methodology. If you find there's a problem when they apply the methodology for the facts in the case, then you could perhaps renew your objection. So I'm going to overrule your objection at this point without prejudice in case you wish to renew it at a later time. Okay?
Yes, Your Honor.
All right. Please proceed, Ms. Sun.
Yes, Your Honor. So back to the question. What was the next step of your method, Mr. Lockhart?
I had to check for originality. In exotic animal investigation, I would compare the fur, the facial features, and the bone structures of animals to identify them. In this case, I compared and contrasted the original facial features of the figure to those of Jimmie Tanks.
So how did you check for the facial features?
I used Harlike feature selection, a method commonly used to compare two sets of facial features.
Well, Mr. Lecard, what is a Harlike feature selection?
I made a demonstrative to explain this, showing examples of how the edges of facial features can be identified by the pixel colors and the structures. Now, let's take a photo of someone's face, like David Attenborough, for example, famous for his exotic wildlife documentaries. By filtering the photo to black and white, you can categorize the ways that the pixels fit together to form the lines and edges of his facial features, like his nose, his eyes, and his mouth. Here, there are four main types of pixel patterns: vertical, horizontal, straight lines, and diagonal ones.
Could you analyze an example of a facial feature for us?
Of course. Here is the same photo from before, and what I'm actually going to do here is I'm going to choose one of his facial features to zoom in on, so we can see the pixels. I'm going to go with his nose, and when looking at the nose, you can normally find pixels indicating a vertical line, like my reference photo on the very far right. So if we zoom in on the edge of the nose, you're going to see almost that exact pixel structure, and with the RGB or red, green, blue values indicating the shades of color. Depending on the strength of the color contrast, we can gauge whether or not this set of pixels shows the edge of David Attenborough's nose, or any figure.
Thank you, Mr. Lecard. So did you find out those facial features that matched up with Mr. Tanks?
Yes, in this case, I achieved a 74% match with the face of Mr. Tanks.
And moving on, what was the next step of your investigation?
The next step is T for trait. When analyzing the physical traits of an exotic animal, especially ones that are more dangerous like tigers, one common way to calculate its bodily measurements is through taking a photo and analyzing that photo. And that's what I did to analyze the physical traits of the figure in the footage and compare them to those of Mr. Tanks.
So, Mr. Lecard, how did you analyze the physical traits of the figures?
I conducted biometric measurements of the figure in the footage to calculate the shoulder to height measurements of the ratios of the figure, and I found out that it had a 97% match to Mr. Tank's data.
So, Mr. Lecard, what's your final conclusion?
Incorporating all of the evidence, I made an integrated conclusion that Mr. Tanks was the figure in the footage walking past with a red plastic container that looked a lot like a gasoline tank just 78 seconds before the fire started.
Thank you, Mr. Lecard. No further questions, Your Honor.
All right, cross-examination, Ms. Chittori.
Your Honor, may I respond to a previous objection I just had?
I apologize, Ms. Chittori. I must have missed it. Let's rewind the tape slightly. What was the objection, Ms. Chittori?
The objection was as to their conclusion that the figure was Jimmie Tanks. This is a violation of Rule 704B.
Okay, let me make sure I have that rule handy. 704B. Okay, and why is it a violation of Rule 704B?
Well, in criminal cases, an expert can testify in an opinion about whether the defendant did or not, but they cannot testify on the mental condition such as intent or motive that constitutes an element of the crime charge. Here they are saying that because they're not saying that their opinion is that Jimmie Tanks was most likely in the video. They are stating it as if it is a fact, which goes towards his intent and therefore is an element of the crime.
All right, Ms. Sun, I'm listening. What's your response to that?
Your Honor, saying that Jimmie Tanks was in the security camera footage doesn't show the intent of Mr. Tanks burning down a house. We're just saying that my witness is just saying that he's conclude that Jimmie Tanks was in the photo, but not the motivations or any intent of setting a fire.
Yeah, I gotta tell you, Mr. Tory, I'm not seeing it. You know,
Your Honor,
it's talking, hang on, Mr. Tory, I'm making a ruling. The issue here is talks about mental state or condition. I don't, the testimony was whether that figure was Mr. Tanks or not. I don't think that's a mental state or condition. So the objection is overruled. Continue, Ms.
Yes, Your Honor. Therefore, no further questions, Your Honor.
Okay.
Thank you, Mr.
So
Lockhart.
now I'm at cross-examination, Ms. Chittori.
yes, Your Honor. Good evening, Mr. Lockhart. I'd like to discuss why you took this case. Bertie Darrow is your cousin who took care of your late mother, correct?
That's correct.
And Bertie's house that burned down was your mother's, wasn't it?
Yeah, that's right.
It was even your childhood home, yes?
Yes, it is.
You agreed to review Bertie's video footage because of your family connections, isn't that right?
Yeah, because it was my childhood home, but yes.
Right, and you even offered your services for free because you were so grateful to Bertie, correct?
Yes, but a main reason too is that it was my childhood home, but that is a yes.
Well, I'd like to talk about your examination of this video footage. Mr. Lockhart, in your expert opinion, a camera's hardware may require an in-person examination if it's been in a fire, yes?
Yes,
Yet you did not physically examine the camera, did you?
no, I did not.
And you never went to the crime scene to inspect where the camera was set up, correct?
No,
Well, I'd like to shift gears to the quality of the video. Now, a low quality video can result in false convictions, isn't that right?
yes, it could.
You also claim that low lighting can distort facial features, can't it?
Yes, it could.
Yet Bertie Darrow's camera was not positioned near any light sources, was it?
That is correct.
And there was even a glare on the figure's face in this particular footage, correct?
I filtered the brightness to solve that problem, but yes.
And you also claim that 250 pixels per meter is required to make a positive identification beyond a reasonable doubt, didn't you?
I'm sorry, it's 250 pixels per meter, but yes.
However, Bertie's footage only had 210 pixels per meter, yes?
Yes, but that is still a very high number. But yes,
So this footage does not meet the industry requirement for a positive identification, does it?
that is why I conducted other tests such as biometric tests and other forms of experiments to better identify the figure. But that is a no. That is a yes to your question.
Well, Mr. Lockhart, I'm not talking about the other features you conducted. I'm asking if this particular footage meets the industry requirement for a positive identification. So, just to clarify for the jury, is that a no to my question?
Yes.
Sorry, I'll take a step back. Is that a yes to my question? I apologize. Let's break down how you analyzed the body shape. You measured the body ratio of the figure, yes?
I did, yes.
And you did this based off an assumption that the figure was perpendicular to the ground, didn't you?
Yes, I did.
You also were not here for an in-person investigation as you were overseas, correct?
No, I wasn't.
And Mr. Lockhart, you only produced a hypothetical ratio for the height and shoulder width of the unidentified figure in this footage. Is that right?
Well, actually, in most cases, hypothetical measurements are commonly used in order to better identify the figure. And if these measurements were completely off, the figure and the percentages will completely be off, and they'll be at like very low percentages. But here the percentages were pretty high, so I would say that these hypothetical measurements were able to work well. But that is a yes to your question.
Right, but these percentages only came back as 74%, didn't they?
Actually, I was pretty surprised. 74% in my own experience is a very high number.
So you would
So
say
that
that's,
is a yes.
sorry, you can continue.
Sorry, I meant to say that is a yes to your question.
Right. And you would say 74% is high enough in a criminal case where a man's life and liberty is on the line?
Yes, I would say that in most cases, this is enough. It's a very high number.
Right, and just to confirm for the jury, this is a hypothetical ratio?
Yes,
Well, you said that standards of conversions are used to provide investigators with exact measurements of a person in a video, didn't you?
yes, they are.
Yet you couldn't identify a reliable standard of conversion, could you?
No, I couldn't. That's why I've used other methods to get these ratios to be more accurate, but that is a yes to your question.
Right, and you couldn't do this since you couldn't identify an object of standard size, correct?
No.
Thank you, Your Honor. No further questions.
Okay, thank you, Ms. Chatori. Any redirect examination, Ms. Sun?
Yes, Your Honor. May I proceed?
Go ahead.
Mr. Licard, a 74% match. Is that a high number?
Well, yes. The 74% match doesn't actually indicate a probability, but rather how many features we were able to match. And people can look different in varied scenarios, so with the addition of hats, sunglasses, and other things that cover up our facial features, however, two different people would have a much lower match percentage than 74%. So 74% is still a pretty high match rate.
And after your cross-examination, I want to make some things clear. So, is the high potential ratio enough in this case?
Yes. In my experience as an expert, a hypothetical measurement is more than enough to be able to get the features to be accurate. And if the features were not accurate at all, or
Your Honor,
the measurements were completely wrong, then
prosecution has run out of time.
Okay, you're out of time there, Ms. Sun, is what I'm told.
Okay. Yes,
All
Your
right,
Honor.
thank you very much. Is there any recross examination, Ms. Chatori?
No, Your Honor.
All right, with that, the witness is excused. Thank you, Mr. Licard. Okay, does the prosecution have any other witnesses?
No,
No,
Your
Your
Honor.
All right, do you customarily like to take a few moments of a 5-minute break or something at this point?
Yes, Your Honor.
Okay, very good. So it is 16 minutes after the hour on my clock. We will come back here at 21 minutes after the hour, okay? Okay. Sorry, I realize I'm a minute or two behind my own schedule. All right. Are we ready? Both sides. Let's start with the both sides back.
Yes, Your Honor, the defense is ready.
Okay.
Your Honor,
Let's-
prosecution's ready.
Terrific. Okay, Ms. Campbell, please call your first witness.
Your Honor, defense calls Inspector Reynolds to the stand.
Okay, please proceed.
Good morning. Can you please state your name and spell your last name for the record?
Good morning. My name is Mackenzie Reynolds, or as many people call me, Inspector Reynolds. And my last name is spelled Reynolds.
Well, Inspector Reynolds, can you introduce yourself to the members of the jury?
Of course. I am a senior insurance investigator with the Tilly Insurance Group for I want to say about 5 years now. But I used to work at the police force and work in fire arson investigations, but I'm now retired. Now, Ms. Campbell, I'm going to let you know a little secret here. Forget Allstate, because here at the Tilly Insurance Group, you're not just in good hands, you're in great hands.
Well, Inspector Reynolds, that's great to know, but insurance is a broad field. Do you have any expertise?
Yes, I do.
Actually, Your
I
Honor,
specialize-
counsel testifying.
Say it again, Miss Lou, I missed it.
Counsel testifying, opposing counsel just said insurance is a broad field, and they didn't give the
Okay.
witness.
All right, Miss Campbell, what do you have to say about all that?
Your Honor, this is a known fact that insurance is a broad field, which the witness has testified to already, that her whole insurance company covers multiple aspects. I'm just asking her what her specific expertise is.
I think this is a harmless preliminary question, so the objection is overruled. Continue, Miss Campbell.
Well, Inspector Reynolds, insurance is a broad field. Do you have any expertise?
Yes, I do. I specialize in fire and structure failure after receiving my Master's of Science in Fire and Safety Engineering from the University of Michigan.
Well, now you've told us a lot about what you do, but what specifically have you done on previous investigations?
So, in past investigations, I've led numerous. We would investigate the fire accidents, ensure that the insurance were correct, and even make sure that the fire wasn't deliberately set. I've even testified in at least 50 cases.
Well, Inspector Reynolds, now I want to direct your attention to why we're here today. Did you investigate the fire set on July 1st?
Yes, I did. And today I'm here to testify as to my conclusions regarding the intention and the start of the fire.
And did you rely on any facts or data to reach your conclusion?
Yes. I actually read Bertie Darrow's financial records, his insurance policy, and I looked over some pictures of burn patterns from the scene. I even conducted one of the scientific tests and my personal favorite, the GCMS test, which is the industry standard in my field of work.
Well, did you apply any of your own principles or methods to this case?
Oh, yes, of course. I used the read, research, react method. I read all the documents, researched the fire, and then I talked to a few individuals to get some reactions. I used this method in all of my investigations.
Well, Inspector Reynolds, now I want to take a step back and focus on how you conducted your investigation. What was your first step?
As always, I followed protocol and I arrived on the scene. I examined the damage and I took some samples.
Well, what damage did you observe?
I saw a lot of damage on the walls and multiple burn patterns.
And if I showed you a picture of one of these burn patterns, would you recognize it?
Yes.
Your Honor, let the record reflect I'm screen sharing with the witness as well as opposing counsel only was pre-marked for identification purposes as proposed defense exhibit 6. What is this?
This is a picture of a burn pattern taken from the scene.
Is it a fair and accurate depiction?
Yes, it is.
Has it been altered in any way?
No, it has not.
Your Honor, defense offers exhibit 6.
Any objection?
No objections, Your Honor.
All right, exhibit 6 is accepted into evidence. Go ahead, Miss Campbell.
Now, Inspector Reynolds, can you please explain exactly what we're looking at?
Of course. This is a puddle-shaped burn pattern, as you can see with the red outline surrounding it.
Well, what does this indicate?
It indicates the presence of a highly ignitable liquid. You can almost think of it as spilling water. It doesn't really have a start or an end point. It just forms a puddle, which you can see which forms like things like this puddle-shaped burn pattern.
Now, Inspector Reynolds, you mentioned ignitable liquids. Can you give an example?
Yes. Now, many people assume gasoline when it comes to this type of thing, and I don't blame them. But there are many other common types like paint thinner.
Now, Inspector Reynolds, we've established you examined the outside and perimeter of the house, but did you ever investigate the inside?
Yes.
And what did you find?
Well, I didn't really find much of anything like laptops or common appliances like a fridge.
So, after you found no common appliances or even a fridge, what does this tell you?
Well, it meant that either Darrow had took all of the furniture out of the house or he just didn't have basic furniture.
And did you ever speak to Darrow during your investigation?
Yeah, I did. He told me a little bit about what happened that night, like how the fire started around 12 a.m. on July 1st, and then we discussed his finances some.
And what did Darrow say regarding his finances?
I believe he said that he was working a steady job and he had a business. He even said that he wasn't in any financial trouble.
Well, did you try and verify this?
Of course, I can't just trust what everyone says. So I looked into his financial records.
And if I showed you these financial records, would you be able to recognize them?
Yes, I would.
Your Honor, let the record reflect that I'm screen sharing the witness as well as opposing counsel only was pre-marked for identification purposes as proposed defense exhibit 3. What is this?
This is Bertie Darrow's financial records.
Is it a fair and accurate depiction?
Yes, it is.
Has it been altered in any way?
No, it has not.
And are there any certifications on this document?
Yes, if you look there under financial analyst.
Your Honor, defense offers exhibit 3.
Any objection?
Yes, Your Honor, hearsay.
Your
Okay.
Honor, may I be heard?
I was going to ask you, Ms. Campbell, what do you have to say about this?
Yes, Your Honor. Pursuant to Rule 8036, this is a regularly conducted business activity. Additionally, Inspector Reynolds has relied upon this for her investigation, and pursuant to Rule 703 and Thompson v. Cameron, experts are allowed to use hearsay to reach their conclusions in today's case.
Your Honor, if I may.
Okay, I'm interested in the argument first on 8036 because I'm not sure Rule 703 has anything to do with having this document admitted into evidence. It's really only 8036. That would be the argument from Ms. Campbell. Go ahead.
Yes, Your Honor. We don't believe that this meets prong C of Rule 8036. We don't know if this was a regularly conducted activity that this organization made regular records of, even though Ms. Reynolds is an insurance inspector and she has a lot of expertise in that field. She doesn't work for the First National Bank of Tilly and hence wouldn't know their internal operations, including how often they made these types of records. Hence, prong C is not met.
Your Honor, may I be heard? Your Honor, it is a regular activity for banks to make financial records, and therefore we have met this prong.
The problem, Ms. Campbell, with your response
And
is
additionally, Your
that,
Honor,
Ms. Campbell, you can't talk when the judge is talking. It doesn't kind of work that way. But the problem with your response is that Inspector Reynolds is not a bank person, let alone someone of the First National Bank of Tilly to testify as to prong C that Ms. Liu has raised. And as a footnote, you need to satisfy all 5 prongs. And even though there was only one objection made to prong C, so for purposes of that, that's enough. So the objection is sustained.
Your Honor, through the certification, all the prongs are established.
Okay, and then I'll ask you a question I've asked prior. What is your authority for that statement, Ms. Campbell?
Your Honor, pursuant to 8036, a certification is able to, Your Honor, pursuant to 8036, a certification is able to establish all prongs, and additionally, it establishes that this is a regularly conducted activity.
Your Honor, if I may.
Sure. Go ahead, Ms. Liu.
Your Honor, nowhere does it say that a certification establishes all prongs. Maybe a certification can meet prong D of Rule 8036 to show that it is an authentic document. But this sentence at the end, I, Michael B. Ledger, certify that the above records accurately reflect the financial status of Bertie Darrow, that doesn't say anything about whether or not this record was a regularly conducted activity. So prong C
Yeah,
is still.
no, I got to tell you, Ms. Campbell, I follow what you're saying. Okay, not the least of which is we could get into arguments about Rule 902, 11, or 12. But putting that aside for a second, yeah, I don't see how that certification addresses C. I just, it does not say that, you have a certification and that's all you need. It doesn't address any of these other items. I mean, there's, it could be authentic, but it does not necessarily establish the detail in section C. So the objection sustained.
Yes, Your Honor.
Yes, Your Honor.
Now, Inspector Reynolds, if my co-counsel could please stop screen sharing. Now, Inspector Reynolds, after looking at Bertie Darrow's financial records, did it line up with what he told you about his finances?
Objection, Your Honor. Lack of foundation.
What do you have to say about that, Ms. Campbell?
Your Honor, the foundation has been laid that Inspector Reynolds reviewed the financial records. That Inspector Reynolds reviewed the financial records. Therefore, she can testify as to if this lined up.
Your Honor, if I may.
Wait, I want to hear Ms. Campbell again. You trailed off on your last part of your sentence, Ms. Campbell. Say it a little louder so I can follow.
Yes, Your Honor. Inspector Reynolds has laid the foundation. We have laid the foundation that Inspector Reynolds reviewed this financial record, and we are asking if Bertie Darrow's statements, which Inspector Reynolds has already testified to, lined up with the financial records.
Okay, what's wrong with that, Ms. Liu?
Your Honor, the prosecution's understanding or hearing of that question was after you determined that Mr. Darrow's statements didn't match up with his financial records, et cetera, and we believe that foundation was not laid. However, if the prosecution misheard, we'd be happy to withdraw this objection.
Ms. Campbell, did they mishear?
Yes, they did, Your Honor. All I asked.
All right, hold it. Well, let's rewind the tape then, Ms. Campbell. All right, we'll withdraw the objection and allow you to rephrase the question in a manner that you think addresses the concern. Go ahead.
Yes, Your Honor. Inspector Reynolds, did Darrow's finances line up with what he told you?
No, not when I reviewed them.
And why was this?
Well, he actually had hundreds of thousands of dollars in debt, and one of his neighbors even told me that she often saw him coming home late from gambling, which his financial records lined up with because I found that he had $2,000 in gambling losses just days before the fire at his home.
And did this prompt further investigation into Darrow?
Yes, it did. I now couldn't overlook the possibility of the fire being set by Darrow instead of Tanks.
And what did you find further into your investigation?
I found his insurance policy, which raised some red flags for me.
And if I showed you this insurance policy, would you be able to recognize it?
Yes, I would.
Your Honor, let the record reflect I'm screen sharing the witness as well as opposing counsel only was pre-marked for identification purposes as proposed defense exhibit 1. What is this?
This is Bertie Darrow's insurance policy.
Is it a fair and accurate depiction?
Yes, it is.
Has it been altered in any way?
No, it has not.
Now, where was this record made?
It was made with the Tilly Insurance Group.
And when was this made?
This record was made, I believe, June 1st of 2024.
And is this a regularly conducted activity for your company?
Yes, it is. Here at the Tilly Insurance Group, we take pride in keeping all records safe and sound within our company.
Your Honor, defense offers exhibit 1.
All right, any objection, Ms. Liu?
No objections, Your Honor.
All right, Exhibit 1 is admitted into evidence. Ms. Campbell, please proceed.
Now, Inspector Reynolds, what on this document raised some red flags for you?
Well, if you look here at special conditions, Bertie Darrow had a fire protection clause. Now, this meant if any fire-related damage happened out of his control, he would receive a full coverage insurance payout on his house.
And how much would this full coverage insurance payout be?
Well, since Darrow's home was worth about $925,000, he would receive almost $1 million.
And would he be able to get this money if he would have maybe just sold his house?
No, he wouldn't have.
Now, Inspector Reynolds, earlier you mentioned the test you conducted, the GCMS test. I'd like to focus on that. How does this test exactly work?
Well, it's a very long process. So, we begin with going to the scene and collecting some samples.
And do you have anything that could aid in the assistance of this?
Yes, actually, I have a slideshow, which I used to teach new people at the firm about it, and I use that in today's case.
Your Honor, let the record reflect I'm screen sharing demonstrative, which has already been shown to opposing counsel. Now let's break this down step by step. What was your first step?
So the first step was going to the scene, of course. And when we arrived to the scene, I took 4 samples. Now I took 2 samples from the outer walls, 1 from the porch, and 1 from within inside of the house. Then we run these samples through the GCMS test.
Well, what happens when you run it through this test?
Well, the first portion of the test is the gas chromatography part, or the GC part. And the science of this is very intricate. So you can think of it as putting your bag through the TSA machine. You know how they make you take your liquids out? Well, it's exactly like the GCMS test, which separates those volatile components and provides us with the chemical components to administer the MS portion of the test.
Well, what happens when you administer it to the MS portion of the test?
So during the mass spectrometry or MS portion of the test, again, you can think of it as putting your bag through TSA. So before you put your bag through the machine, you just see a bag. But as it goes through the machine, it tells you exactly what is inside, which provides the third dimension.
Now, third dimension. Could you be a little bit more specific, maybe?
Yes, of course. This just tells you the materials found from the samples taken from the scene.
Now, what did you find to be from this GCMS test?
I found no gasoline, and instead I found rather large quantities of paint thinner.
Well, did you ever find that Jimmie Tanks had access to paint thinner?
No, during my investigation, I actually found that Bertie Darrow was the one who had access to paint thinner.
Was he the only individual to have access to paint thinner?
From my investigation, yes, that is what I found.
No further questions, Your Honor.
Okay, thank you, Ms. Campbell. Cross-examination.
Yes, Your Honor. Good morning, Ms. Reynolds. I have just a few questions for you.
Good morning.
Ms. Reynolds, or Inspector Reynolds, you said on direct examination that Mr. Darrow wouldn't have gotten $925,000 if he sold his house.
Yes.
But, Inspector Reynolds, you're not a real estate agent, are you?
I'm no real estate agent, but I have sold my own home before. And with things like closing costs, you normally don't receive that much money.
Ms. Reynolds, that's right. You've only sold your own home before, but you don't know anything about the real estate market, do you?
Not from the fact that I sold my own home.
So aside from the fact that you sold your own home before, you don't know what would happen to Mr. Darrow's house in the market if he tried to sell his house, would you?
Well, everyone's going to experience closing costs, which takes away from the amount that you believe that you're going to receive.
So, Ms. Reynolds, simply put, you actually don't have expertise to tell us if Mr. Darrow would get $925,000 if he sold his house, right?
No, I do not have expertise.
Well, thank you, Ms. Reynolds. I'd like to move on to something else. You spoke a little bit in direct examination also about paint thinner, the insurance on the house, and Bertie Darrow's debts. But Inspector Reynolds, I just want to quickly clarify. You don't think that this was insurance fraud, do you?
Well, in many of the cases that I've worked on, normally when there's an insurance claim, there's often a motive behind it.
Ma'am, that wasn't my question. My question was that in this specific case about Mr. Darrow's house, you don't think this was insurance fraud, do you?
Well, I can't rule that out.
But you don't think that Mr. Darrow started the fire, do you?
I mean, from the investigations that I've conducted, I believe that he could have started the fire.
Inspector Reynolds, is it your sworn testimony that you think Mr. Darrow could have started the fire?
No, I'm saying from my investigations that it's not 100% saying that Mr. Tanks did it.
Ma'am, that wasn't my question. Is it your sworn testimony that you think Mr. Darrow could have started the fire? Yes or no?
No, that's not what I said.
Thank you. Ma'am, now that we've cleared that up, I'd like to talk a little bit about who else could have started the fire, whether or not they were caught by a camera. You're familiar with Mr. Darrow's security camera footage summary, correct?
I am, but I am no expert in security camera footage at all.
But ma'am, you'd still recognize it if I showed it to you.
Yes.
Your Honor, let the record reflect that we are now screen sharing what has been pre-marked and pre-entered as Exhibit 2. Ma'am, this is the security camera footage summary you reviewed, right?
Yes, it is.
It says here that it was taken on the night of the fire.
Yes, that's correct.
Now I'd like you to direct your attention to these personal security logs. At 11:12:04, that's when Mr. Darrow goes home, right?
Yes, it says that he enters his residence.
That's right. Now, 11:39:01 p.m. That's when an unknown figure walks past with a red plastic container, correct?
Yes.
And then just 78 seconds after that, 10:40 p.m., that's when an orange-red fire glow appears to the left, right?
Yes.
Ma'am, you'd agree that this figure that walks by, they were recorded?
Well, it's security camera footage, so I'd say yes.
Right, they were caught on the security camera footage, right?
Unknown and unidentified, yes.
Ma'am, let's talk about whether or not that figure you just identified and pointed out to us, whether or not they could have started the fire. So, ma'am, you said in your investigation that you took samples from all around the house, correct?
Yes, 2 from the outer walls, 1 from the porch, and 1 from within inside.
Right, so you took samples from both the inside and the outside of the house, correct?
Yes, I did.
You determined that the fire likely spread from the outside to the inside?
Yeah, which was actually strange because normally in accidental fires, they spread from the inside towards the outside. And that's not what I found in this case.
Right, so instead you concluded that this was a deliberate fire, correct?
Yes.
That means somebody set that fire?
Yes, and it could have been either Jimmie Tanks or Bertie Darrow.
But that somebody, regardless of who they were, they had to be on the outside of the house. Correct?
Yes, they would.
And the figure that you just identified for us on the security camera logs, they were on the outside of Mr.
Yes,
Darrow.
the unknown figure.
Ma'am, now I'd like to talk a little bit more about what started the fire, whether or not your investigation was fully complete. So, Inspector Reynolds, you think paint thinner was the most likely fire starter, right?
Yes, that's what the test found, large quantities of it.
Right, then let's talk about how you collected the samples for your tests. You reviewed Dr. Blaze's report as part of your investigation, right?
I did.
And you actually showed to the court today those puddle-shaped burn patterns that Dr. Blaze found?
Yes.
Now, he took samples from those puddle-shaped burn patterns, correct?
Yes.
And then he found gasoline in his tests?
Yes, and there could have been arrows. Who knows?
Ma'am, that wasn't my question. My question was simply that he thought gasoline was the most likely fire starter, correct?
Yes.
But now let's talk about what you did, ma'am. Ma'am, you knew that those puddle-shaped patterns existed, right?
Yes, I did.
You showed it to the court today that they existed.
Yes.
And yet, ma'am, you never took a single sample from those patterns, did you?
No, but I reviewed them in my investigation.
But reviewing them in your investigation, that's not the same as going in and taking a sample, correct?
No, but I took samples from one place and Dr. Blaze took samples from one place.
Right, ma'am. So because you didn't take samples from this place, you didn't find any gasoline in your investigation, did you?
I found no gasoline and Dr. Blaze found no paint thinner. We both could have made errors, but I believe that my test found large quantities of paint thinner and no gasoline.
Right, ma'am. You didn't find any gasoline, right?
No, I did not.
You only found paint thinner.
Yes, I did.
Thank you, Ms. Reynolds. I have nothing further.
Any redirect examination, Ms. Campbell?
Yes, Your Honor.
All right, please proceed.
Now, Inspector Reynolds, the prosecution just came up here and asked you about where you took samples. Now, is it possible that the gasoline Dr. Harley Blaze found could have been from Bertie Darrow's car?
No, I don't believe so.
Well, is it possible? What do you think is the cause of this fire?
I believe that paint thinner was used to start this fire.
No further questions, Your Honor.
All right, any recross examination, Ms. Liu?
No recross, Your Honor.
Okay, with that, the witness is excused. Thank you very much. Does the defense have any other witnesses?
Yes, Your Honor. The defense calls the defendant Jimmie Tanks to the stand.
Okay, Mr. Torrey, very good. Please proceed.
Yes, Your Honor.
Hi there. Oh, hey, Jake, don't touch that. Sorry about that. That was my son, Jake. He's a little troublemaker.
That's okay. Good morning. Please state your first name and the spelling of your last name for the record.
Good morning, Mr. Torrey. My name's Jimmie Tanks. Last name spelled Tamks.
Can you please tell the jury a little bit about yourself?
Of course. I'm a changed man now ever since I got released from jail. And when I did, I had the shock of my life that I actually had a son. It was like my life changed.
How did finding out about your son change your life?
Well, I'm a dad now, so I'm a changed and better man now, too. Apparently, an old girlfriend of mine was pregnant when I got sent to jail. And you know, my son is just my whole world. I think somewhere over here. Oh, yeah, here it is. That's my little Jake.
So cute. And I'd like to direct your attention to why we're here today. How are you involved with today's case, Mr. Tanks?
I'm here today because they're charging me for a crime I didn't even commit. They think I burned Bertie Darrow's house down. I don't know who burned down that house, but I know it definitely wasn't me. So I'm here to set the record straight.
Well, how do you know Bertie Darrow?
We went to high school and had a silly rivalry a while back. Classic plot of the 1984 movie, Revenge of the Nerds. It's childish looking back now.
What are some examples that happened between you guys in this rivalry?
He was the whole reason the school called me a dork, for example, but I would make fun of his grades from time to time, messing with one of his projects, then he'd push me around. Childish stuff. There was also the theft incident.
What is the theft incident?
Well, I just needed some rent money. Inflation was crazy, but I stole stuff I shouldn't have, did things I regretted, and Bertie Darrow caught me. After time passed, I don't take it personally anymore. It was the right thing to do, and I can't blame him for that.
Well, Mr. Tanks, how did this affect you at the time?
Well, I got sent to jail for 3 years, but honestly, it's made me improve myself as a better person, and now, a better dad for my son. If it was me, I would have reported it too. I'm pretty sure it's a crime not to.
how did you improve as a person?
Well, I realized I needed to get my life together. So when I got out of jail, I got a job at the local rehabilitation center so I could help others improve their lives just like I did.
Now, let's look at the day of the fire, July 1st. Did you ever pass by Bertie Darrow's house on July 1st?
Yeah, I did. I passed by his house during my morning run I decided to do since my son was with his mom that day. But I saw some weird stuff while I was passing.
What did you notice?
I saw Darrow pouring something on the driveway, and there was fresh, nasty smelling paint there on the wall. I also saw that Darrow seemed to be moving all the valuables out of the place.
Well, Mr. Tanks, what did you do later that afternoon on July 1st?
Well, I was just watching a movie, and then I had the coolest idea ever for my son to do on the 4th of July that would definitely help us bond.
What was this idea?
Well, I originally went to the store nuts and bolts for supplies to go camping weeks ago, but I realized my son wouldn't like that. So instead, I got the idea to have a snake-like fire wrap around my house and put an American flag on top. How cool is that?
It's so cool. What did you do after you came up with this idea?
Well, I went outside and poured some gasoline just to try things out. This idea was just to make my son happy for our first 4th of July together. So I was testing this idea would actually work and not be disappointed.
Now, I just want to break things down to clarify. Do you recall what time Bertie Darrow's house was set on fire?
Yeah, from what I've gathered, it was around just before midnight on July 1st.
Did you go anywhere later that evening on July 1st?
Yes, I popped over to the closest hardware store in Nuts and Bolts to go buy some gas before they closed. You see, after experimenting with my project, I realized we needed a lot more for it to work. And I got to the store at around 10:30 p.m.
What did you do when you arrived at this store?
Well, unfortunately, they were out of gasoline, so I was directed to another hardware store in Little Hamlet that did have gasoline, which I admit was a long drive, but anything to make my Jake happy. I owe it to him.
Where did you go after you left the store?
Well, I sucked it up and took that 1.5 hour drive to the store with gasoline in Little Hamlet, and then the 2.5 hour drive back to Willow.
Now, let's look at the day after, the day of your arrest. Oh, I'm so sorry. I apologize, Mr. Tanks. Do you recall what time you got home that night?
Well, I left the store at around 10:40 p.m., and it was about a total of a 4 hour drive to the store in Little Hamlet and then back to Willow, which means I wouldn't have gotten home until around 10:40 p.m., which is way past the time of the fire.
I'm sorry, you said 10:40?
2:40, sorry.
Right, and let's focus on the day of your arrest. Now, what were you doing at the time of your arrest?
Well, I was just trying to clean up some extra gasoline for my project before my son came home, and I was pouring it into a waste drum. And then this fire marshal just arrested me.
Did the fire marshal take any actions prior to the arrest?
No, there were no questions asked. All she did was see me pouring the gasoline and arrest me.
Now, I just want to clarify for the jury, did you set the fire that night?
I only passed by Bertie Darrow's house that one time in the morning. I absolutely did not do this. I only had gasoline that day because I was just trying to plan something nice for my son I'm trying to have a bond with.
Thank you. Your Honor, no further questions.
Thank you, Ms. Chatori. Cross-examination, Ms. Sun.
Yes, Your Honor, may I proceed?
Please proceed.
Good morning, Mr. Tanks. I'd like to start to talk about your relation with Bertie Darrow. So on February 21st, 2021, you were at Rick's pawn shop?
Yes, that's right.
In fact, you stole some items and cash from the shop?
I admit I do, but I regret that.
And you were caught on that day, correct?
I was, yes. That's why I went to jail.
And Mr. Darrow, he was the one who caught you. Is that correct?
Yeah, he caught me. Right place, right time, I guess.
And in fact, Mr. Darrow turned you into the police?
I mean, yes, I'm pretty sure it's illegal not to.
So because of that, you had to go to prison for 3 years. Is that right?
Well, yeah, I committed a crime.
And going to prison meant that you lost your scholarship?
Yes, that's right.
And all of that happened because Bertie Darrow turned you in. Is that correct?
No, all of that happened because I robbed a pawn shop.
Mr. Tanks, Bertie Darrow turned you in. Is that correct?
Yes, I answered that already.
So let's move on to what you did in jail. So during the time you were in jail, you had therapy lessons, is that correct?
Yeah, everyone did.
And those therapy lessons were for you to express your feelings through drawing in a journal.
Yeah, that's a perfect way to describe it.
And on that day, May 13th, 2021, you participated in that day's session, is that correct?
Yep,
And you would recognize a copy of what you drew on that day, correct?
I would, yes.
Your Honor, let the record reflect that now we're screen sharing what has been pre-marked as Exhibit 10.
Okay.
Mr. Tanks, you recognize this drawing?
Yes, I do.
And you drew this drawing during the session on May 13th.
Yes, I did.
So it's a fair and accurate of a copy that you drew.
Looks like it.
Your Honor, the prosecution moves to enter Exhibit 10 into evidence.
Okay, any objections?
Yes, Your Honor. Pursuant to 403, this is substantially more prejudicial than probative.
Well, why don't you explain a little bit more about why that is, Ms. Chittori?
Yes, Your Honor. This is highly misleading to the jury as this photo was taken from over 3 years ago. It's a random drawing from a random journal that the defendant drew, and it can mislead the jury to jump to conclusions that just because my client drew this random photo, it somehow correlates to what happened and what we're on trial for today.
Ms. Sun, what do you have to say about that?
Your Honor, 403 has a really high bar, and the prejudicial value has to substantially outweighs the probative value. And here the prejudicial value is that it might be Mr. Darrow's house that Jimmie Tanks drew a fire on. But the probative value is just that we're stating that Jimmie Tanks was the one who drew it. In this case, the prejudicial value doesn't substantially outweighs the probative value of Mr. Tanks drawing it. So I don't think it outweighs more.
Your Honor, may I respond as to those grounds?
Sure, go ahead.
Your Honor, if prosecution claims that the probative value is simply that Jimmie Tanks drew this drawing of Bertie Darrow's house, then the prejudicial value substantially outweighs this. My client didn't even know what Bertie Darrow's current house looked like at the time, so this in no way correlates to what happened that night at Bertie Darrow's house and substantially misleads the jury. So
Yeah,
therefore,
you know, I got to tell you, Ms. Sun, I'm not normally quick to agree on objections on the basis of Rule 403, but I got to tell you, I haven't even gotten to the point of how this evidence is relevant in any way. You know, so at that point, you know, I don't, you know, I don't even, you know,
Your Honor,
I don't even know what the probative value is. And, you know, and in light of the fact that, you know, we're dealing with a claim of arson in this case, you know, it is that there is a danger of undue prejudice to the jury. So on that basis, at least for now, since there's been no showing of any probative value at all, under Rule 403, this exhibit is being excluded. But that doesn't mean you could not conceivably show why, you know, the probative value is not substantially outweighed by the prejudicial effect. But based on what we've heard as of this discussion, it is. So the objection sustained.
yes, Your Honor, motion to strike.
And now that exhibit is stricken and any testimony related thereto is stricken. Please continue, Ms. Sun.
yes, Your Honor. Can I still share this exhibit?
For what purpose?
We can lay more foundation of the probative value.
Well, if you can, it would go toward the identification of the exhibit. So I'm not going to tell you cannot try and lay a foundation to show why there is, why this exhibit is probative at all. But right now, as the testimony has been thus far, it is not. But so for that purpose, yes, you can still use the exhibit, which has been marked for identification, but it's not in evidence at this point.
Yes, Your Honor. So, Mr. Tanks, let's move back. So, this is a drawing you drew during your therapy session with the house on fire,
Yes, it's one drawing.
and it's a drawing of a two-story house.
It's a drawing of a two-story house, yes.
And in the drawing you drew, the house was set on fire.
Looks like it.
So, let's move on. I would like to talk about what you did after you got out of jail. So you made some research online, is that correct?
I make many research, yes, but if there's a specific time and day you'd like to ask me about,
And you would recognize it if I showed it to you?
I'm sure I would, yes.
Your Honor, let the record reflect that now we're screen sharing what has been pre-marked it as Exhibit 5. Mr. Tanks, is this a copy of your search history?
Yes, it is.
And it's a fair and accurate copy?
Looks like it, yes.
And Your Honor, the prosecution moves to enter Exhibit 5 into evidence.
Okay, any objection, Ms. Chittori?
No, Your Honor.
Okay, Exhibit 5 is accepted into evidence. Go ahead.
Mr. Tanks, so on June 1st, you search up, is gasoline safe for fire uses?
Yes, that's what it says there. I believe I was worried about my son in our project. I just wanted to make sure he was safe.
Yes, and in fact, on the same day, you also searched up, how fast can a house fire spread?
Yes, again, I was worried about my son. I'm very cautious with him.
And you searched up on June 29th, how much gasoline is safe to store at home?
Yeah, that looks like it. Again, I was just really worried about my son.
Yes, in fact, you bought gasoline on June 2nd, correct?
I did, yes, among a lot of other things.
Objection, Your Honor, as to lack of foundation.
I don't understand, Ms. Chittori. What is the detail of that objection?
The lawyer has just testified that Jimmie Tanks bought gasoline on June 2nd, yet that foundation has not been laid on the record.
Okay, Ms. Sun, what do you have to say about that?
Your Honor, we're moving to the next step of screen sharing an exhibit.
Okay, so you're saying that you're going to lay the foundation now? Is that what you're getting at?
Yes, we're gonna lay the foundation.
So we'll subject to renewing the objection, Ms. Chittori. We're going to overrule it for now. Okay.
Yes, Your Honor.
All right. Go ahead, Ms. Sun.
Yes, Your Honor. Your Honor, let the record reflect that now we're screen sharing what has been pre-marked as Exhibit 8A. Mr. Tanks, you recognize this receipt?
Yes, I do.
And this is a copy of the receipt of what you bought?
Yes, it is.
It's a fair and accurate copy?
Looks like so.
Your Honor, the prosecution moves to enter Exhibit 8A into evidence.
Okay, Ms. Chittori, any objection?
No, Your Honor.
All right. Exhibit 8A is admitted into evidence. Continue, Ms. Sun.
So, Mr. Tanks, you bought 5 gallons of gasoline. Is that correct?
Yes, I believe that was for my projects.
And those papers recorded that of what a list of what you bought. Is that correct?
I'm pretty sure that's what receipts do. So, yes.
And in fact, gasoline. You were pouring gasoline out when you got arrested.
Yeah, that was leftovers from my experiment of my project.
Yes, in fact, that you were pouring it on the night of the fire.
Yes, I was. It was for my experiment.
And yes, indeed, for your experiment, you needed a lot of gasoline.
Yeah, I wanted my fire to be pretty big.
So therefore, in your direct examination, you said that you went back on July 1st to buy gasoline,
Yes, that's right.
and there wasn't any gasoline in the store. Is that correct?
Unfortunately, no. So I had to take the long haul over to Little Hamlet.
So on that night, you didn't get the gasoline from Nuts and Bolts. Is that correct?
I did not get the gasoline from Nuts and Bolts, no, but I got peppermint gum.
But you stated that you went to Little Hamlet for gasoline. Is that correct?
Yeah, that's right.
Objection,
really
Your
need
Honor,
that
as asked and answered.
Okay, for purposes of this, we'll continue along. But yes, try not to re-ask these questions, Ms. Sun.
Yes. Yes, Your Honor. And you mentioned that you wouldn't be back when the fire started at Mr. Darrow's house.
No, it wouldn't even have been close. I got home at around 2:40 p.m. And 2:40 a.m. Sorry about that.
I believe that after an hour drive to Little Hamlet and back, it's 3:20 a.m. Is that correct?
I'm sorry, but in my direct, I believe I stated it was 2:40 a.m.
Therefore, no further questions, Your Honor. Thank you, Mr. Tanks.
Okay, Mr. Tanks, I understand there's no more time on the, is there any, there's no more time on direct, am I correct?
Yes, Your Honor.
Okay, so Mr. Tanks, you may step down. And I'm assuming there are no more witnesses on the defense.
Yes, Your Honor. Defense rests their case in chief.
Okay, let's proceed then. We could proceed right down to closing arguments. Is that okay?
Yes, Your Honor.
All
Hey.
right, let's,
Your Honor, would it be possible to have a brief recess before closings?
it's up to Mr. Wang if what he says. I'm fine with that.
Yeah, brief recess is fine,
All right,
as
so
long as it's brief.
All right, so it's 10:10, so brief will come back at 10:15. Okay, 5 minutes.
Yes, Your Honor.
All right. Is everybody back?
Your Honor, prosecution's here.
Yes, Your Honor, defense is here.
Okay. Good. With that, let us hear from the prosecution.
Yes, Your Honor. May it please the court. Caught on camera, caught on paper, caught for revenge. Members of the jury, I want to start by simplifying this case into a very simple instance, an analogy of going out with friends. Say that I was going to go out with my friend, Miss Alana Sun. Now we're deciding whether or not we should bring an umbrella because it might rain. And Alana, she says, no, it's not going to rain. We don't need to bring an umbrella. I am sure of it. Take my word. But even as she tells me that it's not going to rain, I can look outside my window and I can see the clouds turning dark and gray. Even as she says that it's not going to rain, I look on my phone on the weather forecast and I read that it's most likely going to rain. Now, even as she says that it's not going to rain, I hear my friends around me complaining about the rain outside, saying that it was raining. Now, members of the jury, my friend can say that it won't rain, but when I see that it might rain, when I read that it might rain, and I hear that it might rain, just saying that it won't, just denying that it won't, that's not reasonable anymore. In this case, members of the jury, Mr. Tanks, he said a lot of things. He said on direct examination immediately and repeatedly about his son. A son at 21 years old, fresh out of prison. His son was the world to him. He wanted to do anything and everything for him, build snake-like fires, drive really, really far, drive so far that he couldn't get back on the night of the fire because it could have been 2 a.m. already. He can say all of that. But the thing is, members of the jury, what he says doesn't matter when he was caught on camera. What he says doesn't matter when he was caught on paper, when he was caught for revenge, because when he is caught not once, not twice, but 3 times, just denying does not work. It's not reasonable. And if it's not reasonable, members of the jury, it's not a reason to doubt our side of the story. Caught on camera, caught on paper, caught for revenge. Now, the consequences in this case are more than just getting wet or getting caught in a rainstorm. It's huge. And the consequences hurt. It's the cause of the fire, the destruction of the house, his possessions, memories, Mr. Darrow's childhood. And that's why we've charged Mr. Tanks today with 2 counts. One of arson, in that he was setting Mr. Darrow's house on fire and burned his house down. And number 2 of attempted murder. In doing so, in setting his house on fire, he wanted to kill Mr. Darrow and almost tried to. Now, in order to prove our side of the story to you, we need to prove to you beyond a reasonable doubt that both charges are true. And we did that today through 3 very simple facts: the camera, the paper, and the revenge. So let's talk briefly about the camera first. Mr. Lacard said on direct examination that it was his professional opinion that it was Jimmie Tanks in that footage, walking by Mr. Darrow's house just 78 seconds before the fire occurred. And now the defense doubted this. They said, well, a 74% facial feature match, that's not enough to show that it was Mr. Tanks. But can they tell us who it is? Can they show who else it could have been? Did they call their own forensics expert to show us that it was Bertie Darrow instead, as their attorneys repeatedly claim? No, they can't. They don't have a reasonable doubt to doubt that it was Jimmie Tanks. Because Jimmie Tanks, he was caught on camera. And number 2, the paper. You saw the receipts of Jimmie Tanks when he went to Nuts and Bolts to buy some things. He bought a lot of gasoline. gasoline that he could have used to start the fire, gasoline that Dr. Harley Blaze found in his investigation. Now, Inspector Reynolds, she said that it was likely paint thinner that started the fire, that Bertie Darrow had paint thinner. She, in fact, drew out this big circle in a demonstrative on her direct examination saying, oh, this puddle-shaped pattern might have paint thinner in it. But the thing is, members of the jury, she never examined this puddle. She showed us, but she never took a single sample from this puddle. She doesn't know what was in this puddle that she never examined. She didn't know if the cause of the fire could have been gasoline. The gasoline that Mr. Jimmie Tanks bought before the fire. Now let's move on to the revenge. Mr. Bertie Darrow got up here on direct examination and told you the exact words of Mr. Tanks. I'm going to kill you. That's the revenge. And when you're caught 3 times, the camera, the paper, and the revenge, when all those 3 things are valid, that's when you must find the defendant guilty. Thank you.
Very good, Ms. Liu. Thank you. Let's hear closing arguments. Go ahead, Ms. Campbell.
Yes, Your Honor. Credit card debt, mortgage payment, and personal loan debt. We all have at least one of these, if not more. Now, $1 million. This would go a long way for most of us. Could fix a lot of things. Even erase all of our debt. Members of the jury, Bertie Darrow had this opportunity, but only if he burnt his house to the ground to receive the full coverage insurance payout on it. And that's why the motive lies in the $1 million payout. Now today, prosecution came up here and spun you a story saying that revenge fueled this fire. When they spun you this story, this means that they took on a burden that they have to prove to you beyond and to the exclusion of every single reasonable doubt, each element of each crime. Now, we don't have to prove anything today, like the prosecution just tried to tell you in their closing argument. We do not have to prove another suspect to the security camera. Now, you've heard beyond a reasonable doubt used, but I want to talk about what it means. You can think of it as getting on a plane and asking the pilot, is this plane safe? And the pilot looks at you and says, I think so. Do you get on that plane? Because members of the jury, if you would not get on that plane, then I submit you have reasonable doubt. And if you have any reasonable doubt in this case, then Jimmie Tanks is not guilty of first-degree arson and attempted first-degree murder. Prosecution has failed to prove 2 things today. First, opportunity. Second, motive. First, let's discuss opportunity. Today, the prosecution presented 2 witnesses. However, neither of them could tell you definitively if Jimmie Tanks set the fire that night. Neither of them could tell you if Jimmie Tanks had access to gasoline the night of the fire, not June 2nd like how they tried to do. And neither of them could tell you if Jimmie Tanks was even at the scene. Well, Gene Loker tried to tell you through a faulty security camera, members of the jury, the security camera that's positive identification did not meet beyond a reasonable doubt, as their expert said so today. And this expert, who is Bertie Darrow's cousin, members of the jury, we provided you evidence that was actually reliable, that was actually credible, and that was actually unbiased. That showed you Jimmie Tanks was nowhere near Bertie Darrow's house the night of the fire. It also showed you someone who was, and someone who was able to set the fire that night. Bertie Darrow. Bertie Darrow had access to paint thinner. Bertie Darrow was home before 12 and before the fire was set, and Bertie Darrow had the opportunity to set the fire the night of July 1st. Now let's discuss motive. What motive did the prosecution even provide you? Today they talked a lot about revenge. In their opening statement, they used the word revenge 7 times. But the revenge they're relying on? A high school rivalry from over 5 years ago? The report of a theft from 4 years ago? Members of the jury, the prosecution is grasping onto straws. Oh, but wait, They don't want you to forget the one threat that Jimmie made, because this one threat made in the heat of the moment when the incident was raw has to mean that he came back for revenge. It has to mean that he tried to burn down Bertie's house and tried to kill him. But members of the jury, I have one question. Why wait? If Jimmie was so full of hate and so full of revenge, as the prosecution, as well as Bertie himself, has said numerous times during today's trial, then why would he wait at least 6 months after getting out of prison to get his revenge? Exactly. He wouldn't. And he told you so today. He got on that witness stand, waived his Fifth Amendment rights just so that he could tell you the truth. That he could tell you he just wanted to be a better dad for his son. The prosecution's motive does not line up because it was never there to begin with. However, someone who did have the motive was Bertie Darrow in a form of $1 million payout. She told you today how she was struggling financially, and she would only receive this insurance payout if she won this trial. So she was spewing everything at you. He wanted revenge, this threat, everything she possibly could. Because she needed this money to solve her death. Now, members of the jury, the prosecution has called Jimmie Tanks a liar numerous times. But the real liar is Bertie Darrow. You heard how Bertie lied about how bad his finances were to cover up his motive. You heard how Bertie lied about having a gambling addiction. And you learned how Bertie lied about who actually set the fire the night of July 1st. The prosecution is asking you to get on their plane, but tell them they need a better pilot. They need better evidence. So when you are given this jury verdict form, you will select not guilty. Because the motive lies in the $1 million payout.
All right, thank you, Ms. Campbell. Is there any rebuttal from the prosecution?
Yes, Your Honor. We believe that we have around 20 seconds left.
Okay,
Your
well,
Honor,
you'll keep it. Yeah, go ahead.
I would like to disagree. I believe prosecution has at max 5 seconds left.
Okay, well, normally in the world of mock trial, there are two timekeepers, so I would normally ask if both of them agree that it's only 5 seconds. Am I correct? We only have one timekeeper?
No, Your Honor, it was around 17 seconds on defense.
Okay, good. Then as the judge, I will therefore split the difference and make it around 15 seconds. Okay, and I know that's not a perfect split. I did do math before becoming a lawyer. So let us go with 15 seconds. Ms. Liu, you have 15 seconds. Everyone synchronize your clocks and please proceed.
Yes, Your Honor. Opposing counsel said that the prosecution's evidence, we need better evidence. But what the defense needs is reasonable doubts. Not experts that come up here and say that Bertie Darrow wouldn't get money selling his house, even though they don't have the credentials. Because he could have sold his house. And then he'd have no motive. Find the defendant guilty.
Your Honor.
Okay, that is time. Thank you, Ms. Liu. All right, everyone will put in their scores. Mr. Wang will offer his comments.
Thank you so much, Judge Norman, and congratulations. Jordan, yes.
Could I just ask really quickly for all the witnesses to repeat their real names?
Or if everyone could put their names on the screen.
Yeah, actually, that would work.
We have to show everybody should put their faces on the screen with their real names, because that way we can fill in the information of knowing who's who from what. And if you want to put your last names in there, it's Mr. Tanks and Mr. Darrow and Ms. Reynolds, so we know who these witnesses are. That would be helpful. And the lawyers also should show up. We should have all of the lawyers on the screen also. We have to nominate lawyers and witnesses by name. So, thank you.
Stephen, I think I have your ballot. Is that correct?
Your Honor, I believe one of prosecution's witnesses is not in this call right now. It was Mr. Jean Locard. I can type in his name in the chat if that's okay.
That's excellent. Thank you so much. Jordan and Stephen, if you can let me know once you've submitted.
Yeah, I will. It'll probably be about 2 minutes for me. I'll make it as fast as possible.
Sure, take your time. Take your time.
My papers have been submitted. I'm waiting for the email to come back to me with my answers because I want to remember what I said.
Yeah, I think I have yours.
I still am not sure. Where are the names for all the witnesses? Are they in the chat?
They should be in their Zoom box. Or do you want private? Do you want to type to me like whose name you want, or
Yes, please. Let me.
yeah, I'll see if I can get that.
Just submitted, Max.
Okay. I think you did click submit already. Was that an accident?
I don't think I did. It didn't show me that I did, at least.
Uh, might be auto saving. No worries.
Yeah, I just got the email with all the responses that I just submitted. So I mean, if there was another copy, I'm not sure, but that's the only
No,
email.
yeah. So you submitted, right?
Yes.
Excellent. All right. Thank you, everybody. Thank you for that wait. And I think, a round of applause for both teams. Excellent jobs to both of you. And of course, either getting up early or staying up late. Kudos to everybody here. And obviously, a huge thank you to Judge Jordan Katz and Stephen Newton. Man, we can't do this without you two. I am going to start with some quick comments as I have to just make sure the tabulation of ballots are in. So if you can give me a couple minutes and then we'll go to Jordan and Judge Newton. But I really enjoyed this round. I think it was extremely close to me. I really enjoyed, I think there's two things I really enjoyed. One, there were multiple back and forth objection battles between, I think almost every examination there was. And secondly, I just want to give a call out to Jimmie Tanks over there with, I don't, is this real? I can't tell, but there were one or two moments in your cross-examination that really just made me smile where, I don't know, went to buy peppermint and what was the other one? Well, the reason is that I robbed the convenience store. Yeah, that was pretty funny. But having said that, I do wish to present with a few more comments if for the next potentially two rounds going forward. And I'll probably just give two to keep things short. Uh, I think that most attorneys will have to spend more time mastering the rules of evidence. That's quite simple. But there's two more things I think you could do here. One, react to the judge. I think Judge Noodleman has a very obvious way of Q&A that's quite straightforward. Don't interrupt the judge. Answer questions like, if he asks for something, answer that question, right? It's pretty straightforward. But on top of that, it's usually smart to use what's called an IRAC method when you go to objections. The issue, the rule, the application, the conclusion. I recommend doing that in the future. One more comment in regards to witnessing, and this may change from person to person, but I'm generally not a fan of what I would call over-the-top acting. I think that mock trial has a lot of acting and theater, but to me, it's different from Shakespeare. It's different from what you would do in a school play. I generally prefer to see witnesses who are more natural. If this is somebody who's an accountant, if this is somebody who's a police officer, chances are they want to come here, talk their piece, and get out of here. That's natural to me. Chemistry between the directing attorney and the witnesses is important to me. Having a bit of humor is important to me. But anyhow, I've written very, very long comments, and I hope that could help all of you. But once again, congratulations. Excellent round. I'm really glad I took this evening to judge everybody. I'm going to go and make sure I got the tabulations out, and let's hear it from Judge Katz and Newman, please.
Want me to go first? Great. Yeah, high level round. I've judged a lot of these for the competition back in the fall and this one as well over the weekend. Very balanced on both sides. And I think what's great, and this might sound weird, but I think it's great because the balance wasn't just like you were both here the whole time or you were both here the whole time. Each of you had your highs and lows, and I think they really matched each other. And I love to see that in a round that you just have two good teams who are able to compete on that level. Some very specific things that I think apply to everybody actually. Zoom is weird, and I'm sure y'all have gotten there at this point after competing in this competition in this format for a while. Eye contact is super important, but also super difficult. If you're looking at the camera like where your image or the witness's image is displaying on the Zoom, you are not making eye contact with the people who are watching you. You're either looking down beyond the camera or you're looking off to the side. You have to be looking straight at the black hole at the top of your screen. And that can be really hard. Something that helped me when I was doing this in high school was putting like colored tape, a box of colored tape around the camera on my computer. And that makes sure that you're staring right at that screen, because there's a huge difference between this and this. Like even that small change matters so much to a jury who's trying to perceive how well you're communicating with them. So for attorneys and witnesses, I think that's something to really keep in mind. I would say as well, Max brought it up, listening to what is going on is really, really, really important. Honestly, like at the end of the day, we care about your content, you know, all of the facts that you have prepared. But as a judge, especially for attorneys, what I'm looking for is your ability to manipulate those facts in real time, which means responding to things that you didn't plan for, or things that change during the round, or something, a question that gets asked that you weren't prepared for. And I think both sides could do a better job of taking a moment, listening to either what the judge is telling you to do, like what happened in a few moments, what the witness has said on cross. Maybe it's an unresponsive answer that you weren't expecting. Don't let that throw you off. I think on Zoom, sometimes it's difficult to portray the same level of confidence that you might be able to have in person. And so you have to do even more with your body language, with your voice, with your facial expressions to maintain composure and not, you know, show any breaks in momentum or anything like that. I would say as well, think about for witnesses, the listening applies to you, because if there's a sustained objection, for example, to foundation on your direct, it's not the attorney's job to get that foundation, it's your job. So you have to know the rules of evidence just as well as your attorneys to know, hey, what was that objection that just happened? And what do I need to do to help out whoever's directing me so we can fix this problem? I think those are some overall things that you could implement in the future. Like Max, I left some very detailed comments, but thank you for letting me judge. I'm glad to have this opportunity.
Okay, last and not least, I think you all did a very good job. Just so you know how I've been judging these things a lot. I've also judged prior rounds of this competition. And I agree, this was a very, very well matched round. I think everybody, the witnesses were terrific and the lawyers are terrific also. My comments were a lot smaller in between, but let me just embellish them a little bit so you get a general understanding. On the openings, it's helpful, and the defense did this and the prosecution did not. It's helpful to name your witnesses and make a nice, easy roadmap for the jury to follow. It's important, you're going to hear from such and such, he's an inspector and he's going to tell you such and such. Next, you'll hear from, it's not really fancy, okay, because I like the whole idea here is, right, the two main lessons to learn is A, you're talking to a jury, and B, you're paying close attention to what's going on around you, including the comments from the judge. I talk to all of you candidly the way judges have spoken to me over the past 30 years. And that's kind of how I know. So when you hear me say, come back in 5 minutes, okay, and the time is now 31 minutes after the hour, that's exactly how a judge would talk to me. And I have tried a case on Zoom in federal court in Manhattan, New York City. So it is a little different, but it is certainly doable and not impossible. But I do like the focus from both openings that, one side focused on 3 things, the other one focused on 2 things. And why I like that approach on both sides is because it's easy for a jury to follow. You want to make sure you're talking to a jury they can easily understand, and they can come back and see, everyone likes to do these little catchy phrases and rhymes and all that in the beginning. And that's all well and good, but I tend to like it the way both teams did it, in setting forth very clear things. I like, the only time I think I've heard this in a long, long time was on the defense closing. And that is that I like to hear a firm conviction in your position. None of this, well, at the end of the day, you're going to hear from my co-counsel and they're going to ask that you please find such and such guilty. That's lovely. That's not as firm a conviction of, at the end of the day, ladies and gentlemen of the jury, you're going to find no choice and you must find the defendant guilty. A lot firmer in your convictions. I say this at countless judgings of mock trial, and yet I believe the defense closed with that firm conviction. So I finally, somebody somewhere heard me say it and listened. And it's just, I think it shows that you have a stronger belief in your case and a little bit more passion and feeling behind it. As far as one of the objections that went over everybody's head in this whole trial was something called speculation. There was a lot of speculation that was being asked about and testifying about, and nobody objected on the grounds of speculation. Had that objection been raised, in all likelihood, it would have been sustained because there was a lot of speculative testimony and it just went by on both sides. Also, as it relates to the first witness, the prosecution was definitely on what I would call a roll. Okay, when that happens, it helps if you throw in an objection because you want to try and knock them off of their game. This is a high level competition. You're dealing with a lot of smart people who've done this plenty of times and know what they're doing. So you certainly want to try and knock someone off their game if they're really going on and on and on. Now. Again, the witness, I made a comment, needed to pivot a little when the insurance policy was not allowed into evidence, and they needed to adjust their testimony accordingly. Maybe they could have gotten some information from that into the thing, but they didn't. As far as exhibit number, and this goes again, one of my biggest things, if you take away nothing from me today, the one thing you should take away, and Max had alluded to this, and that is you must know these rules, okay, of evidence, and maybe even a few cases, okay, because like happens to me in trials, okay, judges say, what is the basis of your objection? And they'll also say, what is the authority for your position? What is the legal authority? So if you're going to say objection, such and such, they have the rule book handy. You should have, and I did one of these, the last one I did, I think, in the prior original round. Somebody didn't know the rules, and they didn't have the rule book handy. You cannot do that. Okay, you have to know the rules, and you got to cite to the right rule. Okay, because the judge is going to follow along. And if Rule 8036 has 5 parts that have to be met, okay, you should be aware of the 5 parts that have to be met. And the odds are, believe it or not, that somebody is missing one of those parts. And that's exactly what happened. Okay, and you'll see in my comments, I don't know why there was no objection to exhibit number 2. If you look at Rule 8036, all 5 components were not met. As it relates to the expert's ultimate conclusion, the objection should have been not under Rule 704, but under Rule 702. Now, originally I had commented, I said, oh, by the way, this objection might be premature. The objection that would have been premature was the objection under Rule 702, which is why you have to know these rules. Because had the objection been made under 702, it would have been sustained due to a lack of foundation. And then that would have left the other side, the prosecution, in a pickle, because they would have had to go back and relay the foundation that they didn't lay. Okay, so I'm following the rules. This is why, judges do this, and, they've got the rule book handy. You too should have the rule book handy and know what the rules are. I'm not sure why Exhibit 6 was not objected to, okay, due to a lack of authentication. That was a photograph. And if you'll notice, it was not a certified photograph. When you have a photograph that's being admitted into evidence, okay, remember, okay, an exhibit has to be both authenticated and it's got to come in as not being hearsay or have some relevance or basis and so on to be into evidence. There was no authentication. Authentication, well, who took the picture? When was it taken? What is it supposed to depict? Nobody objected. It comes in. I'm not going to object for anyone. And just keep in mind also, when thinking about objecting on exhibits, okay, judges are not going to give you bonus points if you say no objection, Your Honor, it's good. On the other hand, they're going to give you a point if you think, maybe I came up with a creative objection argument that I could make. And then the other side is likely not going to be prepared for it, and you'll win the day on that one. So keep that in mind. The House, that was an excellent objection on Rule 403. 9 times out of 10, Rule 403 objections do not happen. Okay, however, No one at all showed why that was pertinent or relevant for this case, other than it's going to, quote unquote, inflame the jury, okay? Because we're going to see a picture of a house and think it has something to do with the arson at issue. And there was no connection made. So as far as I'm concerned, that does become prejudicial. And that was a good argument on that particular basis. I wasn't sure why exhibits 5 and 8A weren't objected to on the grounds of hearsay. Okay. You know, again, you got to look. And then if there's a hearsay, and then you got to look at the certification, well, there's a rule for the certification to see if the certification is acceptable. These are the kinds of detailed arguments that you get into. But I liked, in terms of the closings, I very much liked the prosecution's closing. Very strong ending, as I indicated, must find the defendant guilty. And I also liked on the defense, I thought that was a very good explanation of the beyond the reasonable doubt standard. Very important to do that. Now, as it relates to my last comment on the going over the top, okay. You know, I watched for that closely. I did a trial, mock trial in Princeton University this past weekend, and the defense witness lost her spouse, was killed or something, or her father was killed. So she got up on the stand and she started to sob, and then she got serious again, and then she sobbed a little more. And uniformly, everybody in the room thought that this was the best witness of all. And she got extremely high marks because she measured her reactions. She didn't cry uncontrollably. She, you know, but she was able to be very persuasive. And even my other judge next to me said, you know, I don't know, she should really go for the Academy Awards. This woman was terrific, and she really was. Now I liked Javier over there. I thought he was Mr. Lang. I thought he was very good. Okay, but you know, some people, but this is an eye of the beholder thing. Some people could think he was a little over the top. Some people could say, you know, he was a little passionate. You know, his house was burnt down. This is, you know, all the possessions. You know, there is something to be said for that. So I kind of like that. In this case, I did not think you were over the top. I thought you were very good. But I could see, certainly it's one of these things you got to be a little careful of. You know, but all the witnesses were good. I too was very persuaded with Mr. Tanks. I thought he came across nicely, handed the little picture of the baby. All that was, you know, all goes to being, you know, very good. And I thought the Inspector Reynolds was, you know, I believed her. I thought she was very serious looking, you know, telling us the facts with a very straight face, took her business very seriously and explained her methods. And, you know, and keep in mind this business with the experts. Okay. The idea is you want to let them do their methodology. And then when there's the argument, it says, okay, and what's your conclusion? You know, at that point, you can object and say lack of foundation because they failed to meet one of the standards under Rule 702. Okay. And that is, I have granted that objection. So when that has happened, sometimes people don't do what they're supposed to do with their experts. And it always surprises me, you know, mock trial, it's between the expert final conclusion and the business records, 8036, that I see more and more and more people don't do those things properly, even though they come up a lot. So you probably want to give a little more attention to those rules, 8036 and 702, when dealing with experts. But again, this is I say it all the time, this is a very hard thing to do. I never did this back in the olden days when I was your age. I never did this. You make a lot of lawyers that I see in day-to-day practice look pretty crummy. So you should be very proud of yourselves for doing a great job.
Thank you so much again, Jordan, Stephen. Thank you so much for volunteering your time. First of all three judges, we were given the option of voting the MVPs in terms of both witnesses and attorneys. So I'm going to announce that first. In terms of attorneys, congratulations to Sydney Liu. For witnesses, it was a split decision, but congratulations to, I'm going to have a hard time pronouncing this, Mr. Jimmie Tanks. Brandon Blainer. Now, ballots will be released to you shortly, but with this particular round, it was a split decision. So congratulations, with a 2-1 going to the next round, the defense for Lauderdale. Congratulations. Again, excellent job, everybody. And I look forward to seeing all of you soon. It's getting a bit late here for me, so unless you have any questions, I'm going to sign off. Congrats. And I'll stop the recording as well.